Good day, everyone, and welcome to the Independent Women's Forum Amicus Brief Conference. Today's call is being recorded. At this time, I would like to turn the conference over to Hadley Heath. Please go ahead.
Hi, good morning. Thank you for joining us. My name is Hadley Heath, and I'm the Director of Health Policy at the Independent Women's Forum. The Independent Women's Forum, IWF, is a nonpartisan 501c3 research and educational institution. It is our mission to advocate for limited government, personal responsibility, and free markets, and to counter the presumption that all women want and benefit from the growth of government. Our website is www.iwf.org, and a copy of our Amicus brief in PDF will be available on the homepage following this press call. At IWF, we comment on a variety of economic policy issues, but we do not take a stance on abortion or the morality of contraception. We believe that gender equality and access to health care, including preventative care like contraception, are compelling government interests. However, our interest in this case stems from a deeper issue. We believe that this contraception mandate may ultimately harm women by adversely affecting health and employment options and impinging on religious liberty. First, let me discuss how this mandate might affect women's health with a specific focus on access to contraceptives. IWF notes in our brief that American women already have access to affordable contraceptives. Absent a federal mandate, 90% of employer plans already cover the full range of contraceptive services. For low-income women, the government already offers free contraceptive services, and private sector organizations work to help women access contraception as well. If our lawmakers believe that it is in the public interest to expand access to contraception, we believe there are better, less harmful ways to do so than to impose this mandate on employers. For example, the government could expand eligibility to programs that provide free contraception, offer tax deductions or credits for contraception, or perhaps best of all, the government could elect to make birth control available without a prescription. The American College of Obstetricians and Gynecologists has already recommended this. This policy would remove third and fourth party payers like insurance companies and employers from the equation and allow women to directly consume the drugs of their choice. Instead, this mandate goes in the opposite direction, requiring even first dollar coverage for the full gamut of contraceptive services. As a free market organization, we believe this is bad economic policy. This will further remove price transparency and price competition from women's choice in contraceptives. Consider this. If the price for all drugs is held equally at zero, consumers will rationally select the contraceptives with the highest value, perhaps choosing brand name drugs over generics. We believe the real winner here is not women, but drug companies who will be able to raise prices on their various products without the notice of their consumer base. This higher cost will be wrapped into higher insurance premiums. We should also consider how this mandate will affect women who remain uninsured. The Congressional Budget Office projected in its latest score of the Affordable Care Act that 30 million people will remain uninsured in 2022. If only half of these are women, then a potential 15 million women could remain uninsured. As the mandate facilitates higher contraception prices, these uninsured women will face even greater difficulty accessing the contraceptives of their choice. Whenever government intervenes, there are unintended consequences. Another unintended consequence for public health is the choice that sexually active couples make about condom use. Condoms are one affordable and reliable form of birth control, but are not included in the mandate for first dollar coverage. Therefore, couples may forego condom use because of the incentives created by this mandate. This could have an adverse effect on the rate of sexually transmitted disease. Secondly, let me speak just briefly to women's employment. This mandate overlooks the fact that women and their families benefit from a flexible work environment that allows them the option of their preferences. IWF has always been a strong advocate for workplace freedom because we believe women who are seeking to balance work and life are better off when they face a greater array of choices. While many women use contraception, not all women would choose contraceptive coverage as part of their compensation. Some women may prefer a higher salary, the ability to work from home, or different health benefits. Government should not make this choice for women. Instead, these choices should be in the hands of individual women and their families. Interestingly, already 190 million health plan participants are exempt from this mandate. This includes small employers, grandfathered health plans, and certain religious employers like churches. The government chose to exempt hundreds of millions of women from this mandate, which undermines the government's argument that this mandate is in the compelling interest of the public. Because this mandate does not advance women, and for the reasons I've discussed, may even serve to harm women, we ask that the court strike it down. IWF believes in a pluralistic society where people should be free to live in accordance with their beliefs. This extends to women who choose to use contraception as well as employers who choose not to offer contraceptive coverage. In our Amicus brief, we offer other possible and historical scenarios that illustrate how such a government mandate would be viewed if the issue were not contraception coverage but other goods and services. Members of the gay and lesbian community, for example, would rightly be offended if all employers were required to offer coverage for conversion and reparative therapy. If you support same-sex couples and find conversion and reparative therapy morally abhorrent, you would not want to expend your resources on coverage for such services, nor should you be forced to do so. This case is about more than contraception. It is about the principles of liberty that animate our Constitution. It is about empowering women to choose the health care and salary options that best fit their needs. And it is about employers, many of them women, being able to follow their deeply held religious beliefs. All of these are reasons that IWF has an interest in this case. Now it's my pleasure to introduce Erin Hawley, a professor of law at the University of Missouri. Erin wrote the IWF Amicus brief. She's a former clerk for Chief Justice John Roberts and will further discuss the key points of our arguments, including the Anti-Injunction Act arguments. Erin?
Thank you so much, Hadley. It's a real pleasure to be involved in this case because I think it's a statute that Congress has really specifically contemplated. In the Religious Freedom and Restoration Act, Congress sought to prevent just this sort of mandate by a later Congress. That statute, the Religious Freedom and Restoration Act, is responding to United States Supreme Court decision called Smith. And in Smith, the Supreme Court held that generally applicable laws apply to religious adherence. To put that in more practical terms, what the Supreme Court held was that Native American tribes were not allowed to smoke peyote because it was a controlled substance. Congress said no. Congress said that religion is entitled to special protections, and in particular, instated a strict scrutiny test. So where a government regulation substantially burdens religion, then the mandate must be both narrowly tailored and further a compelling government interest. As Hadley explained, this mandate does neither. With respect to the narrow tailoring point, there are all sorts of safe and effective ways for women today to access contraception. There are a number of affordable options for women of substantial means, and for those who cannot afford it, there are a number of programs, as Hadley mentioned, to provide free contraception. For example, 9 in 10 employer plans already cover the full range. 28 states require insurers to cover the full range of FDA-approved contraceptions, and public funding for free contraceptive services totaled $2.37 billion in 2010. For this reason, the affordability and current accessibility of contraception, the government may have exempted over 190 million health plan participants. That is, there are 190 million women who are not covered currently by the employers. And as Hadley said, this really undercuts the government's argument that this mandate furthers a compelling government interest. The mandate does not apply to small employers with less than fewer full-time employees. It does not apply to old health plans, and it exempts certain forms of religious organizations like churches. So the fact that the government feels that these organizations and plans don't need to be covered undercuts the fact that they argue others do need to be covered. And as Hadley said, there are some concerning effects of the mandate that in fact suggest that the compelling government interest does not apply here, even though women's interest in affordable health care and contraceptives may in fact be compelling, that interest is not furthered by this mandate because it could actually harm women by increasing the price of contraceptive service and making it more expensive for both covered and uncovered women, as well as having other health effects and detrimental effects on their employment options. One thing that IWF argues is the ability of women to choose a flexible work environment is an option that's highly valuable. Women may choose to prioritize higher salaries or the ability to work from home over generous contraception coverage. And IWF's briefs argues that interest, that decision should be left to individual women and their families rather than a top-down government mandate. IWF's briefs also argues that if the Supreme Court's privacy jurisprudence, its religious jurisprudence tells us anything, it's that the deeply personal choices about when life begins and about whether or not to use birth control are decisions for those women and their families, again, not for the government. One issue that may come up in this case is a really old statute from 1867 called the Anti-Injunction Act. And what the Anti-Injunction Act says that if you're going to challenge a tax, then you have to pay the tax first and then file a refund claim. So it enacts a pay first, litigate later type of regime. What this means, for example, is if you have a dispute with your income taxes, then you have to pay the amount that the IRS says you owe, and only after you pay that amount can you file a refund action in federal court. Well, this seems to make sense for revenue-raising statutes like the income tax, but it's an entirely different matter if this statute might apply to those claims brought by Hobby Lobby, Conestoga Woods, and individuals and companies like them. The idea would be that since the contraception mandate is enforced through penalties paid by the IRS, Hobby Lobby and Conestoga cannot even raise their claims to religious liberty. They cannot challenge or raise the harmful effects this mandate causes to women unless and until they pay the tax. This would be a huge burden as the taxes levied on Hobby Lobby are upwards of $1.3 million per day, an amount that would surely destroy their business. Well, the First Amendment doesn't contemplate such difficult choices between raising a First Amendment right and bringing claims of religious liberty. So rightly, the court has held that in almost every situation where you have a Hobson's choice between raising your First Amendment right and paying a draconian fine, then a pre-enforcement suit is available and the federal court doors are open. IWF argues that this should be the case here because the Anti-Injunction Act is not jurisdictional. And a jurisdictional statute has really drastic consequences. What happens is that a jurisdictional statute means that the court's hands are tied. It has no authority to hear a case at all. Thus, if a statute is jurisdictional and it is not complied with, the federal court has no option but to dismiss the case. No questions asked. So there's no exceptions. It doesn't matter that the parties raise a religious claim. So what IWF says is that the Anti-Injunction Act is not jurisdictional for two main reasons. First, although the court's jurisprudence has been confused on the issue since the late 1980s, the court has been holding jurisdictional statutes to a very high standard. They've said that a statute is only jurisdictional if Congress has clearly indicated a jurisdictional intent. Secondly, the statute is not jurisdictional because the court's precedents have allowed parties, particularly the government, to waive the AIA in past circumstances, and courts have also created exceptions to the statute. Those two reasons, the clear statement rule and the Supreme Court's prior precedents that have waivers and exceptions, establishes that the Anti-Injunction Act cannot be considered to be a jurisdictional act. And this is great news for Hobby Lobby and Conestoga Woods as they're able to make their arguments about religious liberty and about women's health. Thank you.
Thank you, Erin. Thank you for joining the Independent Women's Forum this morning to hear details of our amicus brief filed in support of Hobby Lobby and Conestoga Wood and their challenges to to the Obamacare contraception mandate. As a reminder, our brief will be available after this call on the IWF homepage, www.iwf.org. We will now open the call for questions. If you have additional questions now or after the call, please contact IWF's Communications Director, Victoria Coley, at victoria@iwf.org. That's VICTORIA@iwf.org.
And if you'd like to ask a question today, please press star 1 on your telephone keypad. If you are using a speakerphone, please make sure your mute function is turned off to allow your signal to reach our equipment. A voice prompt on your phone line will indicate when your line is open. Please state your name and affiliation before posing your question. Once again, it is star 1 if you have a question today. And we'll pause for just a moment. And I have no questions at this time, but I would like to remind everyone it's star 1 if you'd like to ask a question. And it appears there are no questions at this time.
Thank you. We'd like to thank our operator and thank the participants in this call. Thank you, Aaron, and thank you from IWF to anyone who dialed in to listen to our speakers and to hear more details about our brief. Again, the brief is available at iwf.org. Have a great day. Thank you.
And that does conclude our conference today. Thank you all for your participation.